Hello, I'm Rusten Hurd. I'm an immigration lawyer at Colombo Hurd Immigration, and I'm going to talk to you today a little bit about green card applications in the era of coronavirus. As we sit here today in late March of 2020, obviously coronavirus has had a significant impact across the country, and immigration is no exception to that. However, U.S. Citizenship and Immigration Services is still open and functioning and accepting applications. And making it more of a hurdle, immigration is still holding foreign nationals to maintain status while in the United States. If you do fall out of status while you're in the United States, you may not be able to change status to another type of immigration status. Accordingly, it is important that immigrants consider their options when looking at the possibility of filing for a green card while in the United States. Now, USCIS has announced that all biometrics and in-person interviews have been suspended at this time through April 1st. In fact, it is my understanding that it's likely that USCIS will almost certainly extend that April 1st suspension of all in-person interviews, which includes oath ceremonies as well, naturalization interviews, adjustment interviews, and biometrics through at least April 15th. However, we don't know that for certain at this juncture. There may be a substantially longer suspension of in-person interviews. However, at this point, immigration continues to process applications. Accordingly, if you are about to fall out of status, it is incumbent on you to still file a timely application if you wish to maintain valid immigration status. In terms specifically of green card applications, it's something to look at about filing an application, but ensuring that you file a complete and thorough application. Back in July of 2018, the Trump administration released a policy memorandum that allows for immigration to deny applications for adjustment of status to obtain a green card if the prima facie information is not included. For example, USCIS requires that an I-864 affidavit of support be filed with a I-45 adjustment application for most types of green card applications. Currently, if the applicant fails to include the I-864 affidavit of support, the green card application as a whole is being denied, not rejected. There is not a request for evidence issued, but rather immigration officers have the discretion and generally do deny the application, leaving the applicant likely out of status and of course forfeiting the filing fee associated with the application. Accordingly, it is exceptionally important that a thorough and complete application be filed. Likewise, the Form I-944, which is the form that is utilized for the public charge rule coming into effect on February 24th of 2020, is also required. Now, it's too soon to know whether USCIS is going to deny automatically applications that fail to include the I-944, but it stands to reason if USCIS is denying applications without an I-864, even in this time frame of active coronavirus in the United States, then an application filed without a I-944 may well also be subject to denial. Accordingly, in light of all this, it is exceptionally important that if you are falling out of status, at least as it stands currently, you consider filing your application for your green card now in order to preserve your status in the United States. At the same time, it is extremely important that you also ensure that your application is thoroughly and diligently prepared and includes all the requirements that USCIS asks for in order to ensure it is not denied pursuant to the July 13th, 2018 policy memorandum. Altogether, this is a difficult time, no question about it, across the country in so many ways, and immigration being one of those ways. However, my recommendation is to seek help if you need it from an experienced immigration attorney that can help you with the process.